Nolan Wells' friend Bart and lawyer has finally spoken after audio leak.
We're sinking. Can you all please come?
And is everybody on board in good health otherwise?
Yeah, everybody's on board.
We're sinking. Can y'all please come? Is everyone on board and in good health? Yeah, everybody is on board. Then, beneath the caller's voice, there is noise. Wind, water, people speaking over one another.
9:56 a.m. The boat leaves the original dock. It arrives at Horn Island at 11:14. So at around 4 o'clock, there is a call to the Coast Guard about the boat. NBC News got. So it looks like this is where Horn Island is, and this is where the original dock is that I am referring to. I looked it up, and El Camino Real Road is in Gulf Hills, Mississippi, which is right above Ocean Springs. So I'm wondering if this is the house where they got
That from the real TikTok detective. The boat wasn't sinking. They told Cito it was sinking. What's the truth? Was it sinking and they repaired it? Did they have a leak and they repaired it and kept on SOP?
And somewhere inside that confusion, listeners heard a name. Some heard Bart. Some believed they heard Nolan. Others heard words suggesting something far worse. But here is the first fact that matters. The official recording was not secretly leaked. Mississippi authorities released the Cito call. What spread afterward was something different. Unofficial versions appeared online, labeled enhanced. Those versions arrived with confident transcripts attached. And once viewers read those words, they heard them. Bart Edmiston's lawyer has now answered that audio. Not with an admission, not with a new witness account, with a complete denial and a legal warning. He says the viral enhancement has no legitimacy. He calls it doctored audio, paired with a false transcript. Bart's family goes even further. They say he did not kill Nolan. They say he did not witness Nolan's death. They say he did not conceal Nolan's death. As of today, Bart has not been charged. No public record identifies him as a suspect. But the investigation into Nolan's death remains open, and the official evidence remains largely sealed. So think about what that leaves us with. A grieving family still demanding basic answers. A young man accused across the internet. A lawyer threatening defamation lawsuits. And an audio recording people cannot stop replaying. This is not simply a story about leaked audio. This is a story about what happens when uncertainty becomes evidence. Bart has finally spoken, but through other people. His family released a written statement. His attorney, Russell Latino, spoke publicly for him. And that distinction matters. We have not heard Bart answer questions under oath. We have not watched investigators test his account. We have not seen the sealed investigative file. What we have is his side, presented by counsel. That side is direct. Bart's lawyer says the internet built a murder theory, then attached Bart's name without verified evidence. Latino says Bart was on Horn Island that day. He does not deny Bart reached the troubled boat. He does not deny Bart helped the people aboard. In fact, that is central to their explanation. According to Bart's family, he piloted another boat. When the friend's boat began taking on water, he approached. They say Bart boarded the distressed vessel. They say he removed its transom plug. They say he returned to his own boat. Then he briefly towed the distressed vessel. That explanation places Bart near the emergency call. It gives an ordinary reason for someone to say, Bart, but an explanation is not independently proven, simply because it fits, and a name and background audio proves very little. Here is the question we are sitting with today. Did the recording reveal something investigators missed? Or did the internet manufacture certainty from distorted sound? That question matters beyond Bart, because Nolan's family still lacks a confirmed cause of death. Their independent autopsy listed the cause as undetermined. It did not rule out foul play. The state autopsy has not been publicly released. Prosecutors say the evidence will go before a grand jury. Until then, the public is working around locked doors. That silence creates pressure. It also creates danger. Nolan's parents are asking people to keep looking. Bart's family is asking people to stop accusing. Those demands are not automatically incompatible. A serious investigation can pursue truth without inventing guilt. A serious public can demand answers without issuing death sentences. That is the narrow line this case now occupies. And the audio sits directly across that line. Notice this. The most repeated phrase sounds decisive by itself. Yeah, everybody is on board. But the dispatcher's question came immediately before it. The question concerned the people aboard the sinking boat. It asked whether everyone aboard was accounted for. It also asked whether they were otherwise healthy. So everybody may mean everyone currently aboard. It does not necessarily mean every friend from Horn Island. It does not necessarily include Nolan. That does not settle the larger case. It only shows why context changes sound. Now consider the other viral claims. People posted transcripts claiming background voices discussed Nolan. Some versions claimed panic. Some claimed concealment. Some claimed a direct reference to violence. But those transcripts did not come from law enforcement. They did not come from a certified forensic report. They were created by online listeners and creators, and many were placed beside processed audio. That combination is powerful. You see words, then your brain searches for those exact sounds. A muffled syllable becomes a name. A burst of static becomes a sentence. A stranger's transcript becomes your memory. That is not an insult to the listener. It is how human perception works. And it is exactly why forensic audio has procedures. The lawyer's response focuses heavily on this point. On News Nation, Latino argued the enhancement was unreliable. He said the attached transcript guided people's hearing. His position is simple. The audio does not establish Bart harmed Nolan, and no public evidence currently establishes that either. To be fair, a defense lawyer's statement is advocacy. Latino was retained to protect Bart. So we should not treat his denial as a verdict. But we also cannot treat online suspicion as proof. Both mistakes destroy the same thing. The difference between a question and an accusation. Bart's legal team made that difference painfully clear. On July 29th, Latino sent a 5-page demand letter. It targeted social media personality Kimbra Lay. The letter accused her of publishing false claims about Bart. It also accused her of posting private identifying information. That included his address, home photographs, and property details. The letter says those posts created safety risks. It says Bart received a credible death threat. According to Latino, federal and state authorities were contacted. The letter demands the posts be restricted from public view. It demands preservation of every related digital record. It demands a correction and a public apology. And it gives 5 business days for compliance. But understand what this document is. It is a cease and desist demand. It is not a court judgment. A judge has not ruled the statements false. A jury has not awarded damages. The recipient has not admitted wrongdoing. The allegations inside remain one side's legal position. Still, the letter reveals how Bart's response has changed. Latino lists possible claims, including defamation and false light. He also raises emotional distress and business interference. He warns that evidence must not be deleted. He says platforms may receive preservation notices. And litigation changes the stakes for everyone speaking publicly, because a viral theory can become discoverable evidence. But legal aggression does not answer Nolan's final hours. It answers a different question. How far will Bart go to clear his name? And right now, the answer appears to be very far. The Edmiston family statement adds more detail. They express condolences to Nolan's family. They say Bart wants a thorough investigation. They say he cooperated before hiring a lawyer. According to the statement, he sat for interviews. He answered investigators' questions. He shared his recollections from July 4th. He provided a list of potential witnesses. They say he allowed access to his phone. They say investigators inspected his boat and GPS. They say no warrant was required. They say he shared requested photos and videos. Some preliminary reporting from marine authorities supports cooperation, but the full investigative record remains sealed, so we cannot independently test every claim detail. We do not know what investigators asked. We do not know what data was recovered. We do not know whether anything was missing. We do not know what the GPS showed. We do not know whether every device was complete. That uncertainty cuts both ways. It prevents the public from declaring Bart guilty. It also prevents the public from certifying his innocence. The only responsible position is narrower. Bart says he cooperated. Authorities have publicly described friends as cooperating. No public charge connects Bart to Nolan's death. The investigation has not publicly reached a final conclusion. Everything beyond that requires proof. Yet the internet rarely rewards narrow conclusions. It rewards confidence. It rewards the person who hears the darkest sentence. It rewards the most complete-looking transcript. It rewards the thumbnail promising a hidden confession. And that is where the title becomes important. Bart and his lawyer have finally spoken. Yes, they have. But what they said is being misrepresented already. Bart did not admit Nolan was killed. His lawyer did not confirm a cover-up. The family did not reveal a secret motive. Their public position is the exact opposite. They deny involvement. They deny knowledge of Nolan's death. They deny the rumored romantic connection, and they threaten lawsuits against accusers. That is the development. Not a confession. Not a breakthrough arrest. A forceful legal counterattack. Now, does that counterattack feel defensive? Of course it does. It is a defense. That is not evidence of guilt. Hiring a lawyer is also not evidence of guilt. When your name is tied to a death online, counsel matters. When your address is posted, counsel matters. When threats arrive, counsel matters. The real test is not whether Bart hired counsel. The test is whether his claims match objective evidence. Phone records, GPS data, original audio, witness interviews, boat examinations, and eventually, sworn testimony. That is where the case must go. Not toward louder speculation, toward evidence that can survive challenge. Think about what that means. The loudest version online may be the weakest version legally. A transcript with no verified author has little foundation. An audio file with unknown processing has chain problems. A clip copied repeatedly may contain compression damage. A phrase heard after prompting may be perception, not speech. That does not make the official call meaningless. It means the original file matters more. And Nolan's family understands that. Their attorney, Ben Crump, says they hired audio engineers. Those experts are expected to review the distress call. Crump has also asked for broader outside involvement. His team wants careful examination of the friends' phones. That is the right direction. Because the family should not have to accept internet transcripts. And Bart should not be convicted by internet transcripts. The same forensic process can protect both interests. If the original audio contains useful dialogue, preserve it. If processing reveals speech, document every adjustment. If experts disagree, explain exactly why. If nothing reliable can be recovered, say that plainly. Anything less leaves space for manipulation. This is where forensic analyst Jennifer Owen enters. She is not connected to the investigation. She reviewed the public controversy, not the original evidence. Her warning was direct. Be careful before joining the crowd. Owen says proper analysis begins with the truest file. Not a social media download. Not a screen recording. Not a clip passed through several apps. The analyst needs the original source material. They need the file's digital history. They need to know whether it was compressed. They need to know whether its format changed. They need to document every step taken. And another qualified analyst should reproduce those steps. That is how an enhancement becomes testable. Without that process, enhanced can mean almost anything. It can mean reducing steady background noise. It can mean isolating a frequency range. It can mean boosting certain speech bands. It can also mean over-filtering the recording. And over-filtering can create artifacts. Artifacts are sounds introduced by the processing itself. They can resemble syllables. They can sharpen noise into something word-like. Then a transcript tells your brain what word appears. Think about the mechanics for a second. You are shown the phrase, "Nolan is gone." Then you hear 3 distorted bursts. Your brain now has a target. It searches those bursts for matching sounds. After several replays, the phrase feels obvious. But remove the transcript. Give the same clip to 10 new listeners. They may hear 10 different sentences. That is why the transcript cannot lead the science. The sound must lead the transcript. Notice this. Owen did not declare the call worthless. She said its potential could be enormous, but only if experts work from proper material, only if they preserve the audit trail, only if they isolate dialogue carefully, only if they avoid creating new distortion. Her position sits between both online extremes. She does not endorse the viral transcript. She does not dismiss the official call. She says the work must be done correctly. That may sound less exciting than a confession, but it is far more important, because one verified phrase can redirect an investigation, and one invented phrase can destroy an innocent life. The stakes exist on both sides. Nolan's family deserves every recoverable truth. Bart deserves protection from unsupported criminal claims. Those principles do not compete. They depend on the same standard. Reliable evidence, handled transparently. Now separate the questions. Is Bart's voice present in the call? That is one question. Did Bart assist the distressed boat? That is another question. Did he know where Nolan was then? That is a different question. Did he witness harm against Nolan? That is another question entirely. Did he participate in harm or concealment? That is the most serious question. Online coverage often collapses all five together. It hears Bart, then jumps directly to homicide, but a name establishes presence, at most. Presence establishes opportunity, at most. Opportunity is not conduct. Conduct is not intent. And intent is not guilt, without proof. That separation may frustrate viewers, but it is how fair investigations avoid disaster. The family's statement addresses the highest accusation. They say Bart did not kill Nolan. They say he did not witness Nolan's death. They say he concealed nothing. Again, those are defense assertions. But no verified evidence currently disproves them publicly. That is why the audio analysis matters so much. It may test the defense account. It may support it. It may reveal nothing usable. All three outcomes remain possible. The lawyer also addressed a rumored motive. Online posts circulated an old photograph of Bart. Some users claimed the woman pictured knew Nolan. Then they built a jealousy theory around that image. Latino says the woman pictured was someone else. He says Bart never dated the woman linked online. He says Bart did not know her before Nolan's death. No verified public evidence has established that rumored triangle. So the motive remains an internet construction. That does not mean investigators ignore relationships. It means creators cannot present rumor as established fact. The cease and desist letter makes that point repeatedly. It accuses its recipient of changing theories over time. It says those theories were presented as facts. It claims the audience reached into the millions, and it argues the posts created real-world danger. That last concern is no longer abstract. Federal authorities have charged multiple people over threats. Those cases concern alleged threats around this investigation. They are not charges for Nolan's death. That distinction matters. No arrest announced so far solves Nolan's death. The arrests show something else. Online fury has crossed into alleged criminal conduct. Witnesses have reportedly received threats. A judge's family reportedly received threats. Bart's lawyer says his client received a credible threat. Nolan's family has also faced harassment. This is what happens when a case becomes a battlefield. People stop looking for truth. They begin choosing teams. Every unanswered question becomes proof of conspiracy. Every denial becomes proof of guilt. Every lawyer becomes evidence of a cover-up. Every demand for transparency becomes an attack. But Nolan's death is not content for team sports. A young man died. His parents still do not know exactly how. That fact should discipline every sentence spoken. It should also discipline Bart's defenders. Because false accusations do not erase legitimate questions. The distressed boat is still part of the evidence. The original call still deserves examination. The friend's digital records still matter. The state autopsy still matters. The grand jury process still matters. Bart's cooperation claims should be independently confirmed. His account should be compared against other witnesses. His GPS should be mapped against verified locations. His phone data should be reviewed for gaps. And any inconsistency should be investigated, not monetized. That is the difference between scrutiny and conviction. Scrutiny asks for records. Conviction declares an answer before records arrive. Nolan's family is entitled to scrutiny. Bart is entitled to the presumption of innocence. The public can hold both thoughts simultaneously. So what did Bart's lawyer actually accomplish? He corrected one major false impression. The viral audio has not produced a verified confession. He also established Bart's public defense. Bart says he was a helper, not a participant. He says his presence near the boat was innocent. He says he cooperated fully with authorities. He says online claims placed his family in danger. Then his lawyer backed those denials with legal threats. But there is one thing the statement cannot accomplish. It cannot close the evidentiary gap. Only the underlying records can do that. And those records remain mostly hidden. The public has not seen the original audio file. The public has not seen a certified forensic transcript. The public has not seen Bart's complete interview. The public has not seen his phone extraction. The public has not seen the GPS analysis. The public has not seen the state autopsy. So the most honest conclusion is uncomfortable. Bart has spoken. His lawyer has spoken even louder. But the evidence has not finished speaking. And the next voice may not come from a person. It may come from metadata. It may come from a deleted message. It may come from a GPS coordinate. It may come from a sound nobody heard correctly. Because buried inside the lawyer's aggressive denial, there is a challenge. He says Bart handed investigators everything. Now the question is whether those records tell the same story. And that is where Bart's defense becomes testable. His lawyer says 2 witnesses saw Nolan later. Not minutes later. Roughly 90 minutes after the boats departed. According to Latino, those witnesses are credible. According to Latino, they place Nolan alive on Horn Island. That claim changes the meaning of the emergency call. If Nolan was seen alive afterward, the call cannot prove his death. It cannot prove Bart knew Nolan was dead. And it cannot prove concealment was already underway. But notice the condition inside that sentence. If those sightings are accurate, the public has not seen sworn witness statements. We have not heard those witnesses questioned. We do not know exactly where they stood. We do not know how clearly they saw Nolan. We do not know whether the time was estimated. We do not know whether phones confirmed that estimate. And we do not know whether investigators agree. So Latino's claim is important. But right now it remains a lawyer's claim. That does not make it false. It means it has not been publicly tested. Bart's lawyer says at least 2 people exist. If that is accurate, their accounts could be decisive. Not because they clear every person automatically, but because they reshape the central window. They move attention away from the distressed boat. They move it back toward the island. They also challenge one online theory directly. The theory claims Nolan was already dead on board. The theory then treats background audio as concealment. Later sightings would cut through that theory, but only if those sightings withstand scrutiny. And here is the difficult part. The same public demanding Bart's records should demand theirs. Not their names, not their addresses, not an internet interrogation, their evidence, their timestamps. Their original statements, their basis for identifying Nolan. That is how you protect witnesses and test claims. You do not do it through mass exposure. You do it through a controlled investigation. Because witnesses are now receiving threats. That is no longer a rhetorical concern. Federal charges have been filed against 3 people. Those charges concern alleged threats around this case. They do not concern Nolan's death. One defendant allegedly threatened a witness and family. Another allegedly threatened a judge. Another allegedly made bomb threats to public offices. No court has established guilt in those cases yet. But the allegations show the environment surrounding witnesses. That is why Bart's attorney emphasizes safety. It is also why Nolan's family emphasizes transparency. Both problems can exist at once. A sealed process can create public suspicion. An uncontrolled public process can create intimidation. The answer is not secrecy without accountability. The answer is verified disclosure at responsible moments. That has not happened enough here. The state autopsy is complete. Its findings have not been made public. The district attorney says the case goes grand jury. That will happen after investigators finish collecting information. No public grand jury date has been announced. No person has been charged in Nolan's death. No public ruling establishes homicide. No public ruling establishes accidental drowning. The independent autopsy lists both findings as undetermined. That is the legal and medical position today. Everything else remains argument around incomplete evidence. Now return to Bart's account. His family says he boarded the distressed boat. They say he removed the transom plug. They say he helped drain water. They say he returned to his own vessel. His lawyer says more than 20 people witnessed this. That number matters. A story observed by many people is testable. Investigators can separate those witnesses. They can compare descriptions. They can examine whether details align independently. They can identify language repeated suspiciously. They can compare accounts against boat records. They can check whether physical conditions make sense. But presence is not the contested issue. The contested issue is what Bart knew. The viral transcript claims background words reveal knowledge. His lawyer says those words were manufactured. Forensic testing must decide whether words exist. Witness testing must decide what Bart knew. Digital testing must decide whether his movements align. These are separate evidentiary lanes. Online commentary keeps merging them together. Latino's television appearance did something strategic. He attacked the audio's foundation first. He did not debate each alleged word. He challenged the method producing those words. That is exactly what a defense lawyer would do. Because once the method becomes unreliable, conclusions weaken. He also offered an alternative explanation. Bart was there to help a sinking boat. Dozens of people allegedly saw his actions. 2 witnesses allegedly saw Nolan later. Bart allegedly gave investigators his devices. That is a coherent defense narrative. Coherent does not mean proven. But it is stronger than silence. And it forces investigators to test specific claims. Did Bart surrender the complete phone? Was the device extraction successful? Were location services active? Did photographs contain original metadata? Did the boat's GPS preserve the entire route? Did witness accounts place him continuously? Did any record contradict his stated movements? These questions do not accuse Bart. They evaluate what his lawyer volunteered publicly. When a defense says, evidence clears someone, verify it. When an accuser says, evidence implicates someone, verify it. The standard cannot change with your preferred conclusion. Notice this. Bart's legal team is not demanding silence everywhere. They say they support a thorough investigation. Their demand concerns statements presented as fact. That is a meaningful distinction. A person can ask, why is Bart's name audible? A person can ask, what did Bart tell investigators? A person can ask, does his GPS match his account? Those are investigative questions. Saying Bart murdered Nolan is different. Saying he helped conceal a body is different. Saying a rumored relationship supplied motive is different. Those statements allege specific criminal conduct, and publicly available evidence does not establish them. The cease and desist letter is designed around that gap. It says the posts crossed from questions into declarations. It says private details intensified the harm. It says the resulting danger was foreseeable. Whether a court agrees remains to be seen, but the warning reaches beyond one influencer. Every creator covering this case faces the same choice. Describe what the evidence supports, or sell certainty the evidence cannot carry. That choice affects Nolan's family too, because false theories consume investigative attention. Investigators must chase claims that sound urgent. Families must answer rumors they never created. Real witnesses become buried beneath fabricated witnesses. Authentic files become mixed with edited files. Then, when genuine evidence emerges, trust is damaged. People call every correction a cover-up. They call every uncertainty proof of corruption. They stop distinguishing mistakes from misconduct. And the case becomes harder to explain honestly. The new United Cajun Navy report demonstrates that risk. The volunteer organization compiled a 22-page document. It includes public material and unverified submissions. The organization says it is not law enforcement. Its spokesperson says it was no bombshell. That caveat matters. A polished report can still contain unverified claims. Use it as a question map. Do not use it as a verdict. Its most relevant question concerns the unaccounted period. Not a complete timeline. A specific evidentiary gap. What reliable evidence places Nolan during that interval? Bart's lawyer says 2 witnesses do. The volunteer report says the interval remains critical. Those positions are not necessarily contradictory. The report may not contain those complete statements. The lawyer may possess information not publicly released. Investigators may already have resolved portions privately. Or the claimed sightings may remain uncertain. We simply do not know. And that is exactly the point. The audio cannot be interpreted in isolation. It must be compared against every verified sighting. If witnesses place Nolan alive later, say so clearly. If their accounts conflict, explain the conflict. If digital records support them, release that when lawful. If digital records contradict them, pursue that contradiction. The public should not have to choose between lawyers. The evidence should make that choice unnecessary. Now ask yourself something harder. What would make you change your mind? Not what confirms your current belief. What evidence would actually change it? If Bart's GPS shows continuous movements elsewhere, would that matter? If witnesses place Nolan alive later, would that matter? If the original audio contains nothing incriminating, would that matter? It should. Now reverse it. If Bart's records contain unexplained gaps, would that matter? If his account conflicts with witnesses, would that matter? If experts independently recover significant words, would that matter? It should. An honest theory must be falsifiable. It must risk being wrong. Otherwise, it is not investigation. It is allegiance. Nolan's parents cannot afford allegiance replacing evidence. They have one objective: find out what happened to their son. Their attorney says they want mutual phone inspection. Their experts and state experts would examine data together. That is one constructive path forward. Nolan's mother says messages appeared deleted. The phone had been returned by a friend. Those circumstances deserve forensic examination. But again, separate the questions. Were messages absent? That is one question. Who deleted them? That is another. When were they deleted? That is another. Why were they deleted? That is another. And whether deletion relates to Nolan's death is separate. Cloud records may answer some of this. Platform subpoenas may recover message history. Device logs may show account activity. Location applications may preserve timestamps. Backups may reveal what existed previously. That is why Bart's claimed phone cooperation matters. It gives investigators another device to compare. If his communications remain intact, they matter. If timestamps align with the emergency, they matter. If photographs show who was present, they matter. If metadata places Bart where claimed, that matters. But none of this has been publicly released, so his lawyer's confidence rests on unseen material. The family's suspicion also rests partly on unseen material, and the audience is being asked to judge shadows. That is not sustainable. Eventually, the grand jury may receive more. Witness interviews, digital extractions, marine records, search documentation, photographs and video, potential forensic audio analysis. Then jurors can decide whether charges should follow. That possibility makes official communication important now. Authorities do not need to expose witnesses. They do not need to publish sensitive records. But they can clarify what is being examined. They can correct demonstrably false viral claims. They can confirm whether audio experts are involved. They can say whether key data was preserved. They can explain why the autopsy remains sealed. Silence may protect an investigation. But unexplained silence also feeds distrust. Bart's attorney enters that divided space aggressively. He says his client is being falsely accused. He says people are fabricating wildly. He says real people fear for their lives. The available threat cases make that fear plausible. But Latino also makes an affirmative factual claim. 2 credible witnesses saw Nolan later. That statement deserves follow-up. Were those sightings independently verified? Do timestamps support their memories? Did both witnesses identify Nolan separately? Those are not hostile questions. They determine whether the sightings carry weight. Without answers, credible witnesses remains a label. With answers, it may become powerful evidence. And Bart's lawyer knows that. He placed those witnesses into public conversation. So their accounts now sit beside the audio. One may weaken the other. Or both may fit together. Nolan could have been alive after that call. Bart could have assisted exactly as described. And Nolan's death could still require investigation afterward. Those possibilities can all coexist. That is why solving one disputed moment is insufficient. Even a clean call does not explain Nolan's death. Even a later sighting does not explain Nolan's death. Even Bart's cooperation does not explain Nolan's death. Each fact narrows possibilities. None automatically completes the story. Does this look like panic or a plan? At this stage, that question is premature. The public has not established that either occurred. The actions described by Bart look like assistance. The actions alleged online look like concealment. Only verified evidence can distinguish those narratives. And right now, public evidence is insufficient. That may be the hardest sentence here. Not because nothing matters. Because so much matters, without being settled. The audio matters. The sightings matter. The missing phone content matters. The boat records matter. The autopsies matter. The witness threats matter. The legal letters matter. But importance is not the same as conclusion. Now consider what the lawyer did not say. He did not release Bart's full interview. He did not release the GPS file. He did not release a forensic audio report. He did not name the alleged later witnesses. He did not explain every circulating rumor. That is not necessarily suspicious. A lawyer may withhold evidence during an investigation. Witness identities may require protection. Private records should not be dumped online. But those limits make the public defense incomplete. It asks viewers to trust an attorney's summary. Nolan's family asks viewers to distrust early assumptions. Both sides are asking for patience differently. Bart's side says stop accusing before evidence. Nolan's side says stop concluding before answers. Listen carefully. Those sentences are closer than they appear. Both reject premature certainty. The conflict concerns which certainty caused greater harm. Authorities initially suggested drowning was possible. The family believed that came too quickly. Online users then suggested homicide and named individuals. Bart's family says that came without evidence. The case has suffered two opposite rushes. A rush toward accident, then a rush toward murder. The correct process stands between them. Do not rule out foul play prematurely. Do not identify killers prematurely. Investigate the death with full seriousness. Presume people innocent until evidence supports charges. That is not indecision. That is due process. The emotional cost remains with Nolan's family. Their son cannot correct a transcript. He cannot explain why his phone returned without him. He cannot identify who last saw him. He cannot describe an injury. He cannot tell investigators what frightened him. He cannot explain why he stayed behind. That silence is why records matter. Every device now carries part of his missing voice. Every witness carries another part. Every expert has a duty not to distort it. And every public figure must not exploit it. Nolan's mother said something cutting through everything. He is not here to speak for himself. That is why she continues advocating. Not for a predetermined conviction. For a fair, honest, transparent investigation. She has said they want no special treatment. They want authorities treating Nolan's case seriously. Bart's family says they want that too. If both statements are sincere, common ground exists. Preserve every record. Test every account. Protect every witness. Release conclusions with supporting reasons. Correct misinformation quickly. Charge someone only when evidence supports it. As of August 5th, that has not happened. No one has been charged with Nolan's death. Bart has not been publicly named a suspect. The official autopsy remains unreleased. The independent findings remain undetermined. The investigation remains active. The case is expected to reach a grand jury. The timing remains publicly unknown, and the viral enhanced audio remains unverified. Those are the boundaries of what we know. Everything beyond them requires a label. The family alleges. The lawyer claims. Investigators say. A report suggests. An expert cautions. Social media speculates. Those labels are not verbal decoration. They tell you how much weight statements carry. Remove them, and suspicion becomes fact. Keep them, and the audience thinks clearly. That is what this case needs now. Not less public attention. Better public attention. Attention that knows when to pause. Attention that notices missing proof. Attention holding grief without manufacturing guilt. Attention demanding transparency without threatening witnesses. Because the threats surrounding this case are not justice. They do not honor Nolan. They do not help investigators. They do not make Bart answer more accurately. They make everyone afraid to speak. And fear is a poor substitute for evidence. Remember the audio from the beginning. We're sinking. Can y'all please come? That call concerned a boat in distress. Online, it became something much larger. A confession. A coded exchange. A murder cover-up. A complete theory. Hidden inside background noise. Bart's lawyer says that transformation was fabricated. Nolan's family says experts should examine the original. Those positions create a clear next step. Obtain the original recording. Preserve its chain of custody. Analyze it without a guiding transcript. Document every filter applied. Let independent experts compare results. Then explain what can and cannot be heard. If the words are there, follow them. If they are not, retire the transcript. If the result remains uncertain, say uncertain. Truth does not weaken through careful language. It becomes harder to manipulate. And that brings us back to Bart. He has spoken through his family. He has spoken through his lawyer. His message is that he helped. His message is that he cooperated. His message is that he knew nothing. His lawyer says records and witnesses support him. The public has not seen that support fully. So his statement deserves neither blind acceptance nor dismissal. It deserves verification. That is the same standard Nolan's family requests. Verify the friends' accounts. Verify the phone activity. Verify the witness sightings. Verify the boat movements. Verify the audio. Verify the autopsy findings. Then follow the evidence wherever it leads. Nolan was 18 years old. He was preparing to report for football camp. His family expected him home. Instead, they received his phone. Then they received questions. Now they are fighting through noise for answers. Christine Wansley has said it plainly. We will not rest until we get answers. So here is the question we began with. Did the audio expose something investigators missed? Or did the internet create certainty from noise? Bart's lawyer has given his answer. Nolan's family is still waiting for evidence. Now that you have heard both positions, what matters most? The words people claim they hear, or records that can prove what happened. We will keep following this case. Not until the internet chooses a villain. Until Nolan's family receives real answers.